A Lagos High Court sitting in Ikeja has admitted as evidence the extrajudicial statements allegedly made by former Central Bank Governor Godwin Emefiele while in EFCC custody. Justice Rahman Oshodi overruled defense objections that the statements were obtained through torture and duress. Maogu Josu has the report.
At the day's ruling on the objections raised in Emefiele's case, whether his statements are admissible or not, Justice Rahman Oshodi noted that the Anti-Torture Act 2017 raised by the Defense Counsel Olalekan Ojo governs terrorism cases and not extrajudicial statements. The presiding judge also noted that such matters can only be invoked under the Administration of Criminal Law of Lagos State for mini-trial in consonance with Sections 28 and 29 of the Evidence Act, and not the Anti-Torture Act that was raised by the Defense Counsel while objecting the admissibility of the statement. Justice Rahman Oshodi overruled the objections of the Defense Counsel challenging the admissibility of the statements on the grounds that they were not voluntarily made, therefore admitted the statements obtained on different dates as evidence in the ongoing trial over an alleged $4.5 billion and 2.8 billion naira fraud and abuse of office cases. On the prayers for mini-trial raised by counsel to Emefiele, who is the first defendant, the judge agreed with the prosecution and ruled that a trial within trial is not necessary since the statements were not confessional. Justice Oshodi adjourned the matter to October 7 and 8, November 11, 12 and 13 for continuation of trial. Recall that in June 2026, the former governor of the Central Bank of Nigeria, Godwin Emefiele, challenged the Economic and Financial Crimes Commission, EFCC, that tendered statements made by him in his ongoing trial. His counsel, Olalekan Ojo, SAN, had argued before the court that the statements were involuntarily obtained from the defendant on October 27, 30, 31 and December 1 and 2, 2023, while he was in EFCC's custody, submitting that the statements were inadmissible. Ojo said the objection was predicated on the provisions of the Evidence Act, and the Anti-Torture Act added that Section 4 of the Anti-Torture Act prohibits admission of any confession or statement obtained through torture or other inhumane treatment. The defense counsel consequently urged the court to conduct a trial within trial to determine whether the statements were voluntarily made before deciding on their admissibility. This was premised on the presentation of Emefiele's statement by the Director of Public Prosecutions of the Federation, Rotimi Oyedepo, through the fourth prosecution witness, Alvan Ekoku. Justice Rahman Oshodi therefore adjourned the matter on whether the statements were admissible or not. Maogu Josu, LTV News.